Good evening. There are 15 days left, 15 days left until the general strike on October 15th. The general strike is a one-day action asking people to refuse to spend money, to refuse to employment, take the day off work if possible, and to observe a 24-hour fast, a fast for peace on October 15th, and to use the hashtags Fast for Peace and hashtag VoteAU to call people to vote together with the American Union, a union of swing voters willing to vote for either Democrats or Republicans based on their acceptance and support of our demands, which is immediate passage of this legislative package, the Blueprint for a Better America, demanding Congress that pass it within 10 days. This legislative package would end poverty, end mass incarceration, and end the endless wars. And there's more than 50 different policies within this legislative package. It is all ready to go for Congress to put right on the president's desk if they want. If Congress refuses to do it, their challengers can earn the American Union endorsement. And if they agree, if they meet our terms, then we can happily reelect them all. We can have a peaceful election. We can come out of the pandemic solving these problems. We can end poverty, end mass incarceration, and end the endless wars. Wouldn't that be a much better outcome than years of gridlock in Washington that produce nothing, that don't solve any fundamental problems? We can have functional government, but the way to get there is to crowdsource it. We, the people, can do it ourselves. And as my commitment to seeing this legislative package enacted, I started my fast for peace on September 24th at noon with the publication of the final version of the Blueprint for a Better America. So today is I'm on day 7 of my fast, and my weight is at 191 pounds, and I'm feeling good. And we're going to continue to go through this legislative package section by section so that everyone in America has the opportunity to learn exactly what is in this legislative package, what exactly these demands are. This isn't something that Congress would do where you have to pass the legislation in order to find out what's in it. No, this is public information. This is open source, an open source legislative package that everyone can see, read, and understand. If you have questions, please put them in the chat. I'll be happy to answer them. And every 4th day, we also do a recap day. The next one is coming up on Sunday, October 2nd. So we'll be taking any questions people have. We can answer them then. If they're about previous sections of the bill that we've already addressed. As well as October 2nd is the birthday of Mohandas Gandhi. And we'll be talking more about the principled nonviolence that makes up the foundational principles of the American Union. So today we are going to continue where we left off, starting with sections 151, amending the Espionage Act. Let me go ahead and share my screen here. Okay. The Blueprint for a Better America. Again, you can find this on our website and AmericanUnion.com. And you can also find it on, you can download it directly through a bit.ly link. 2022 Blueprint Summary includes a summary of the legislative packages, 50 different policies. In 2022 Blueprint Summary, the words blueprint and summary are both capitalized. But today we're going to continue in Title I, Establish Justice. Oh, you know what? Before we get into this legislative package, I would like to remind myself and America what about our mission statement as a nation, and that's the preamble of the Constitution. As you saw, Establish Justice is our first duty under the Constitution. And so let's go ahead and recite the preamble. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. This legislative package is based on those 5 duties. Our first one being to establish justice. And so I'm going to go ahead and continue. We've already talked about the police reforms, and today we're getting into prosecutorial reforms, clarifying offenses related to espionage, clarification of the Real ID Act, repealing mandatory minimums, and then we'll get into the Mathew Charles Prison Reform Act and second look legislation, modification of certain terms of imprisonment. So, okay. Clarifying certain offenses related to espionage. Now, in short, what this does is it requires that for a conviction under the Espionage Act, it requires a specific intent that the information is to be used to injure the United States or advantage a foreign nation. And that is, so it goes through the Espionage Act and adds that language in a couple different places. It clarifies that anyone who has that intent in order to commit espionage, they have to take something that has been properly classified with national defense for it to be, and that having unauthorized possession of documents or anything like that is not espionage unless it is done willfully with the specific intent to injure the United States. This part of the legislation largely comes from something that Tulsi Gabbard had introduced, the Protect Brave Whistleblowers Act. And in addition to clarifying how espionage could be, what the burden of proof for proving espionage was. There's also the opportunity for people to disclose information, whistleblowers to disclose information to members of Congress, federal courts, Inspector General, the Privacy and Civil Liberties Oversight Board, the Commissioner, the FTC, the Federal Trade Commission, the FCC, or any other person or entity authorized to receive disclosures containing classified information pursuant to applicable law, regulation, or executive order regarding the protection of whistleblowers. In addition, a defendant charged with an offense, charged with espionage, shall be permitted to testify about the purpose for engaging in the prohibited conduct. And it would be an affirmative defense that the purpose of the prohibited conduct was to disclose and inform the public of any violation of law, rule, or regulation, gross mismanagement, gross waste of funds, abuse of authority, or specific danger to public health or safety. All right, I'm going to stop the share there. And why do we want to amend the Espionage Act? What is the purpose of doing this? You've probably heard of the Espionage Act in relation to a couple of cases. Most recently in the case of Donald Trump and the possession of classified documents at Mar-a-Lago. Those, as we've gone through here, in order for a charge of espionage to be proven, you'd have to prove a specific intent to harm the United States. So the Espionage Act applies today, is generally used not to go after people for actual espionage. Let's look at what that means. Look in the definition of what espionage is in the dictionary. Now, according to Webster's New World College Dictionary 5, espionage is either the act of spying, The use of spies by a government to learn the military secrets of other nations, or the use of spies in industry or commerce to learn the secrets of other companies. And so let's keep that definition in mind as we talk more about how the Espionage Act has actually been used in recent years. And the way it's actually been used is to intimidate whistleblowers. The Espionage Act of 1917 was signed into law June 15th of that year. And we're in the middle of World War I. So anything that might throw sand into the gears of war, the war machine, that could be considered espionage. But it was really under President Obama that the espionage took on a new form, going after whistleblowers. A senior executive with the NSA, Thomas Drake, he had been criticizing a program that they were running, the Trailblazer programming, which tracked people using cell phones and emails. And so he complained to superiors about privacy and other management problems. And then in 2010, this senior executive with the NSA was charged with espionage under Section 793E. And they charged him with this, threatened him with up to 35 years in 35 years in prison. And when unstated, they don't have to prove that the defendant actually intended to harm the country. But if we remember, that's what the definition of espionage is. And so if the Espionage Act doesn't have to prove that, then it's not really espionage. It should be updated. Now, another NSA contractor, Edward Snowden, he saw this for what it was. It was a warning to other employees and contractors with the NSA, don't be a whistleblower. But in 2013, Edward Snowden made international news when he revealed that the NSA was spying on Americans through a variety of programs, including collecting bulk telephone data, scanning private emails. He'd seen the director of national intelligence, James Clapper, directly lie under oath to Congress. And so he realized something had to be done. He's got a great quote. He says, "I had been looking for leaders, but I realized that leadership was about being the first to act." And for his leadership in revealing to the American people what was being done in their names, he was charged under Section 793D and Section 793A of the Espionage Act. Now, after he left the country to Hong Kong to reveal this information, the State Department canceled his passport while he was on a plane, left him stranded in Russia on his way to Latin America. And when he tried to get political asylum from other countries, the United States pressured them to refuse. So he has been stuck in Russia since 2013, and he will likely remain there until the Espionage Act is amended. As a postscript to that story, in 2020, the Ninth Circuit Court of Appeals ruled that the bulk collection program was illegal. Despite that, Edward Snowden is still under threat of prosecution for revealing that it was being done. Another case came about in 2017 with another NSA contractor named Reality Winner. She was charged under the Espionage Act after mailing one sheet of paper to the press showing that Russia had tried to interfere in the 2016 election. And for that one sheet of paper, she was charged under Section 793E, sentenced to over 5 years in federal prison. Her pleas for a pardon from President Trump and Biden were ignored, but she was finally released last June. And I want to emphasize that both Edward Snowden, Reality Winner, had served in the military. They loved their country and believed that the American people had a right to know about what was being done. They did not have the intention to harm the country, did not have the intention to advantage a foreign nation, and they weren't spying on things in commerce and industry. So what they did was clearly not espionage, but they weren't charged under this law, which is why it needs to be amended. Now, the last case I want to talk about is Julian Assange, who is not an American citizen. He's an Australian citizen, and he was the co-founder of WikiLeaks. He drew world attention in 2010 with the participation of Chelsea Manning when he published all sorts of documents, videos of American soldiers in Iraq shooting 18 civilians, including several journalists from a helicopter. They published hundreds of thousands of field reports from the Iraq and Afghanistan war. They published 250,000 diplomatic cables showing that America wasn't just spying on its own citizens, but on our allies themselves. And so while Obama didn't went after other whistleblowers, he did not go after Julian Assange because this case is different. Publishing government documents is something that is protected under the First Amendment of the United States. It is the freedom of the press. This has been litigated before. This is well established in law. In 1971, the Pentagon Papers were published by the New York Times, showing the American people how they'd been lied to about the escalation of the Vietnam War. And when the government got an injunction, the Washington Post continued to publish the Pentagon Papers, and then 15 other papers until finally it worked its way up to the Supreme Court, which ruled 6-3 that the press couldn't be restrained from publishing this information. And so WikiLeaks, in publishing this information, is doing exactly what publishers have always done. But President Trump changed course in office and began to try and prosecute and extradite Julian Assange, charging him with 17 counts under the Espionage Act. And President Biden has continued these legal efforts to bring another citizen to the United States from another country for doing something that is not, for publishing information in accordance with America's constitutional principles. So Julian Assange saw this coming. And so he sought asylum in the Ecuadorian embassy in London in 2012. And for 7 years, he stayed inside that building until 2019 on the basis of a U.S. extradition warrant. The police were invited into the embassy. He was arrested. And now, for more than 3 years, he has been incarcerated in the maximum security Belmarsh prison, charged with 17 counts under the Espionage Act. And again, this is for publishing information, something that newspapers do all the time. When Edward Snowden revealed the depths that the NSA was going through to spy on American people, the many newspapers published that information. That's what newspapers are supposed to do, is inform the public. And Julian Assange did the same thing, and yet he's being charged with espionage. So the espionage needs to be amended, and that's what Section 151 of this legislation would do. Seeing no questions in the chat. All right, we're going to move on to Section 152. This is clarification of the Real ID Act of 2005. Now, the Real ID Act was a piece of legislation that had kicked around the House, and what it had done was set national standards for state driver's licenses back in 2005. And the way it became law was that the House tucked it into a must-pass piece of legislation. The Emergency Supplemental Appropriations Act for Defense, the Global War on Terror and Tsunami Relief of 2005. And so by tucking this provision into a larger piece of must-pass legislation in a committee of conference report, it went before the House and the Senate, and all they could do is vote up or down on it. Senator Clinton objected, but the Senate voted 100-0 to adopt this committee of conference report, including this provision that they had opposed. And so this was one of the reasons that I ran for state representative in 2006, was to try and make sure that people's privacy protections stayed in place, and that a framework for a national ID card a system of requiring identification in order to travel around your own country. A system of internal passports did not end up being put in place. And so that is the main threat of the Real ID Act, is that it says that non-real IDs won't be accepted for identification when boarding a commercial aircraft. Now, this was supposed to go into effect in 2008. Then it was postponed to 2009, then 2011, then 2014, then 2015, then 2018, then 2020, then 2021, now 2023. And so this is a bluff. The United States cannot require internal passports in order for people to travel around the country. And that is essentially what the Real ID Act would do. There is no law requiring citizens to show ID to travel. That would run into constitutional issues. And so Section 152 is basically just one sentence. For the purposes of boarding a federally regulated commercial aircraft, the credentialing requirements of Section 202 of the Real ID Act of 2005 shall only apply to people required by federal law to show identification as a condition of boarding a federally regulated commercial aircraft. Again, there is no such law. If Congress wanted to pass such a law, then the Supreme Court could review it for its constitutionality. But until they do, this would clear up the bluff. This would demonstrate to the states that this was an unenforceable provision and would not be able to be enforced. All right, Section 153. Seeing no questions in the chat. Section 153. This section would repeal mandatory minimums. So I want to talk a little bit about what the history of mandatory minimums are, the theory, and then what this section would do specifically. In 2016, 55.7% of the federal prison population had been sentenced under a mandatory minimum provision, carrying an average sentence length of 110 months. And mandatory minimums have been around for a long time. They were signed by George Washington, our first president, when they passed the first crime bill in 1790. It had 23 crimes, and 7 of them carried a mandatory death penalty. The other 16 crimes just had maximum sentences. So it was a little different in those days. A number of these had to do with things like piracy. And Congress started getting back into these mandatory minimum sentences after it abolished the slave trade. You could get 5 years for bringing slaves into the U.S. You'd get a mandatory minimum of 5 years for bringing slaves into the U.S. and 2 years for serving on a vessel that was carrying enslaved people. After World War II, the use of these increased, and the Anti-Drug Abuse Act of 1986 contained the framework for a lot of the mandatory minimums that we have today. A lot of them involve the war on drugs, but as we'll see, there are dozens of others. And the premier organization that works on this issue is FAM, Families Against Mandatory Minimums. They've been doing this for 30 years. They were founded by a woman whose brother got a 5-year mandatory minimum sentence for growing marijuana in Washington state. And so I'd like to share some of their arguments about why the practice of mandatory minimums should be abolished, should be repealed. The first is that mandatory minimums do not deter crime and make the public safer. Deterrence assumes that people will research the criminal code, find the relevant mandatory penalty, and then be discouraged from the criminal activity because of the penalty. But in reality, people are not generally aware of mandatory penalties when they violate the law. And therefore, increasing the penalty or severity is ineffective at deterring people from engaging in criminal activity, because If they don't think if they're going to commit a crime, it's because they don't think they're going to get caught. So the harsher possible sentence does not serve as a deterrence. What does deter it, crime, is being caught and punished quickly, not lengthy sentences. Mandatory minimums also fail to create consistency or uniformity in sentencing, despite that being the objective, because mandatory minimums, they just transfer sentencing discretion from judges to prosecutors. Prosecutors decide who, when, how to charge. Prosecutors use the mandatory minimums at different rates from jurisdiction to jurisdiction. They create sentence disparities and inconsistencies. Mandatory minimums also create a trial penalty, where prosecutors charge those who exercise their right to trial by filing charges that carry mandatory prison terms. Whereas if somebody makes a deal, then they can get a shorter sentence. This is part of the reason why I think 97% of criminal cases end up resolved not with a trial, but with a plea deal. Mandatory minimums also create unwanted racial disparities in sentencing. There's a study of federal sentencing patterns that showed that Black people are more likely than their white counterparts to be charged and convicted of offenses that carry mandatory minimum sentences. According to a 2014 University of Michigan study, researchers found that federal prosecutors are 65% more likely to charge Black defendants with offenses that carry mandatory minimums, 65% more likely. Now, this charging decision ultimately results in lengthier sentences for Black defendants and contributes to racial disparities in sentencing. Like, take, for example, drug-free school zones, which often require mandatory minimum prison sentences for buying or selling drugs within a certain distance of a school. They impact people of color disproportionately because they are more likely to live in cities and dense communities with overlapping school zones. They are hit the hardest by these harsh drug-free school zone laws. For example, prior to reforms in 2010, Black and Hispanic people in New Jersey made up 96% of the people convicted and incarcerated under the state's school zone law. 96%. A couple more reasons on why these are ineffective. Mandatory minimum sentences are not necessary to ensure sufficient punishment, and they actually create unjust, excessive results that make us less safe. Eliminating mandatory minimums does not mean that people won't be punished or imprisoned. It means that courts won't have the right to imprison people indiscriminately without considering the facts. Repealing mandatory, as you will see as we go through section 153, none of the maximum penalties change. All we are doing in this section is striking the mandatory minimums. And mandatory minimums also require courts to send people to prison, even if prison is unnecessary to keep the public safe, to keep people in prison just past the point where they pose a danger and to others. Again, remember the Weldon Angelos case where he was sentenced to 55 years on mandatory minimums for selling marijuana for a nonviolent offense. This is not justice. So what does section 153 do? It repeals 67 different mandatory minimums from the US Code. I should say that a lot of the mandatory minimums that are contained in as part of the drug war, the Controlled Substances Act, those are all repealed, but there's 67 other mandatory minimums that are repealed. And there are serious crimes here. There are. Again, this section, repealing mandatory minimums, does not change the maximum penalty that an individual can be sentenced to. All it does is restores the ability of judges to judge. It gives them the ability to make these decisions instead of giving the power to the prosecutors to decide to charge someone with a mandatory minimum, a crime with a mandatory minimum sentence. And so the federal government has the opportunity to lead by example in restoring this power of judges to judges. And I say we have the opportunity to lead by example at the federal level, but actually over 30 states have reformed or repealed their mandatory minimum sentences in the past 2 years while maintaining public safety. In 2017, Louisiana repealed many of its mandatory minimums, and in the first 6 months alone, the state saved $12 million. The state's prison population dropped to a level not seen since the 1990s, and the state reinvested that money into crime reduction and victim support programs. In 2015, Pennsylvania's many mandatory minimum sentences were struck down as being unconstitutional, and since that ruling, crime rates have continued to decline, including during the 6 years that from 2012 to 2018 that the state's prison population declined. And in 2002, Michigan's legislators, they repealed almost all mandatory drug sentences, and the state's crime rate dropped 27% in the decade following the reform. All right, I'm going to share my screen again, and I'm just going to quickly go through some of these 67 different repeals. All right, and so a lot of these are small ones for less than 1 month. Some of these are minor offenses, less than mandatory minimums of 1 month, 6 months. I had a breakdown of how these worked out. So a bunch of them were for short sentences, a bunch were for long sentences, but I don't remember what that breakdown is. So let's see, a lot of these are for mandatory minimums of less than a year. And I think as we've talked about before, 71% of Americans say they would be more likely to support a politician who removed mandatory minimum sentences. And so this is a good deal for Congress to do something that 71% of people say that they would like, and strike these things from the code. So yeah, so a lot of them, there's a 10-year mandatory minimum, less than 1 year, a 2-year mandatory minimum, 3-month mandatory minimum. Some of these, there's a 5-year, the death penalty. So this would require a mandatory sentence of death or life imprisonment, and this legislation would keep both of those on the table, but change it to subject to imprisonment of for any terms of years. And so some of these things these crimes that stack as additional penalties, like the use of carrying a gun during the commission of a crime. One of the things that Weldon Angelos was used against him, that he was carrying a gun while he was selling the marijuana. And so we're changing these from shall to may, that the judge may decide to tack on additional punishment, but it would no longer be mandatory. And so we'll see this in a number of other places, changing these additional items from shall to may. There's another 5-year, 7-year mandatory minimum. The 20-year mandatory minimum, 10 years, 5 years, 7 years. And again, this isn't to lighten the seriousness of these crimes, only to say that mandatory minimums, that a statutory penalty that is unalterable, does not establish justice by taking away the power of judges to judge. Changes more shalls to mays, striking a 20-year mandatory minimum. Some of these oldest mandatory minimums come from the deal with piracy. And so a lot of these crimes of piracies carried a mandatory sentence of life imprisonment. Some of these are sort of eclectic, like whoever being a seaman lays violent hands on his commander to hinder and prevent his fighting in defense of his vessel or the goods entrusted to him is a pirate and shall be imprisoned for life. Yeah, so that mandatory minimum for laying violent hands on your commander in defense of their goods on a ship would no longer carry a mandatory life sentence in prison. It would be up to the judge to decide any term of years, up to and including life. Another one, whoever holds out or shows any false light or extinguishes any true light with the intent to bring a sailing vessel on danger or distress or shipwreck had a 10-year mandatory minimum. Still can be public punished for any term of years or for life. So it's a bunch of these that relate to piracy. We've got some more death or life imprisonment. Again, can be done for any term of years. There are some serious crimes against children that have mandatory minimums. And this would not change the maximum penalty of up to any term of years or life imprisonment. There's more 5 years, 15 years, mandatory minimums, 10 years, 5 years, 15 years, 10 years, 20 years. And so if you are a defendant who is being charged with or the prosecutor has a variety of things that they can charge you with, when mandatory minimums are thrown out, it's an extra way for prosecutors to coerce a plea bargain. Again, something like 97% of convictions come as a result of plea bargains, not of actual trials. And so to establish justice, you need to give people, take away that trial penalty. Yeah, so you can read in the legislative package, you can read all of the changes that are made and all the different mandatory minimums that are removed. Everything is available here. 1 month mandatory minimum, 3 month, 1 year, another 1 year, 30 days, 6 months. And some of these milder ones aren't necessarily the problems, but as a matter of principle, all mandatory minimums would be struck from the U.S. Code so that judges could judge. There's another 20 years, death or life imprisonment, changed to subject to imprisonment for any term of years. So that is what Section 153 does. Seeing no questions in the chat, I think we can move on to Section 161. I wanted to touch on how other countries use mandatory minimums. And in fact, in many cases, courts have found mandatory minimums to be unconstitutional in countries like Canada, India, Sri Lanka, South Africa, and Papua New Guinea. I think it's also important to, again, as the United States is the world leader in mass incarceration, that it's important to recognize and reflect on how we are over sentencing and overcharging and people, the things that we've done that have led to this problem of mass incarceration. In 2016, there were 161,957 people who were serving a life sentence, and 53,290 people serving life without parole in the United States. So more than, not quite a 250,000 people, but that was compared to 50 people serving a sentence of life without parole in the United Kingdom. So there's a huge difference in the way that America establishes justice and other countries do. And so to get back to our constitutional duty to establish justice, we can repeal mandatory minimums. All right, that is the last part of the Weldon-Angelos Justice Act and the prosecutorial reforms. Now we get into the Mathew Charles Prison Reform Act. And this has a bunch of reforms and related to prisons or treatment of incarcerated Americans. And section 161 has the findings. Just to talk a little more about to go back to what this legislation is. This is a legislative package for Congress. This is federal legislation. And so it can only directly tell the Federal Bureau of Prisons what changes they have to implement. So that covers 122 federal prisons. It's more than 134,000 prisoners, which is more than any individual state. But with our national prison it's still a small percentage of our national prison and jail populations. But this is the opportunity for the United States on the federal level to set an example and to do the things that will end mass incarceration nationwide. So the findings from the Mathew Charles Prison Reform Act are that the United States has an incarceration crisis that has destabilized millions of Americans and is failing in its constitutional duty to establish justice. More than 2/3 of federal prisoners serving life sentences have been convicted of nonviolent crimes, including 30% convicted for a drug crime. And there are tens of thousands of people over the age of 50 who remain locked up, even though they are elderly, sick, and pose little to no public risk. And approximately 97% of incarcerated Americans will be released. Therefore, it is in the best interests of all to position them to succeed when they are. So we're going to reform conditions for incarcerated Americans, and that is what section 161 is the findings. Section 162 is modification of certain terms of imprisonment. And the text from this section comes largely from the Second Look Act of 2019, introduced by Cory Booker and intended to be a follow-up to the First Step Act signed by Donald Trump in December of 2018. And it's based on a fundamental principle that individuals are capable of redemption and self-improvement. People change, people mature, people grow up. Like the repeal of mandatory minimums, this section will create the opportunity for judges. As Brian Stevenson has said, each of us is more than the worst thing that we have ever done. And to which I would add, by definition, the worst thing each of us has done is a statistical outlier. Now, this section that would allow sentences to be reviewed and reduced is needed because federal parole was abolished in 1984. And so what this does is allow incarcerated people in the federal system to request a sentencing review after 10 years, 15 years, 17 years, or if they're over the age of 50, or for crimes whose penalties have changed, like mandatory minimums, as we'll see when we get into this. This is not automatic by any stretch of the imagination. All it is creates a path for incarcerated people to have a hearing, to have counsel, for both sides to submit evidence, and again, for any sentence modification to take place, it would require a positive finding that the defendant is not a danger to the safety of any person or community, that the person demonstrates readiness for reentry, and that it is the interest of justice to modify the sentence. They'll also be asked to consider factors about the defendant's age. We have thousands and thousands of people locked up for long sentences in this country who were charged as juveniles, as young people whose brains were not fully formed. And look, I'm not the same person I was 10 years ago. I'm sure you're not either. And this is always true. And to lock up a young person for decades and decades under the presumption that they are incapable is not incapable of change, incapable of redemption, is not justice. All right, so let me go ahead and share my screen, and we're going to go through this. Okay, 162, modifications of certain terms of imprisonment. And then a new subchapter in the United States Code. And this is enabling legislation. Notwithstanding any other provision of law, a court may reduce a term of imprisonment if that they've been, and these are the conditions that would enable someone to request a sentence review. They've been in prison for more than 10 years. That's sort of the standard one. But then, because this is a part of our larger legislative package, if their imposed term of imprisonment was the result in whole or in part of a mandatory minimum sentence, they would be able to request a review, or was the result in whole or in part of a drug offense that is no longer punishable pursuant to the enactment of the Weldon-Angelos Justice Act. So if you're there for a sentence that that we've changed the underlying code around, that's grounds to ask for. It doesn't entitle you to hear one, but it entitles someone to ask for a sentence review hearing. So he said the court would have to find that they weren't a danger, ready for reentry, and the interest of justice warranted a sentence modification. Sorry, I take back one of those things I just said. If they're under for a drug offense, this would be mandatory that they shall conduct a sentencing review on request, and ensure that the counsel has the defendant has counsel under the Defender Services Program, which the Department of Justice runs. And notwithstanding any other provision of law, there is a rebuttable presumption that the court shall reduce a term of imprisonment imposed on a defendant if the term of imprisonment resulted in whole or in part from a drug offense. So it would not be mandatory, but the presumption would be that if you're incarcerated for a drug crime that's no longer a crime, that your sentence would be reduced. Set in place a framework for supervised release and conditions for supervised release. We talked about yesterday about how drug offenses would automatically be expunged, and so this would automatically expunge them for people after a sentence hearing under subsection B. Other factors and information to be considered in determining whether to modify a term of imprisonment. Factors include the age of the defendant, at the time, how old they were in the present day, presentation of argument and evidence by counsel for the defendant, report on how their behavior has been in prison, if they have substantially complied with the rules of the institution, if they've completed any educational, vocational, or any other programs. So again, considering these things to, once again, give people a path to demonstrate, to improve themselves, to be rehabilitated. And the sentencing modification program would put a light at the end of the tunnel. So if someone is doing these things, it will increase their odds of having a sentence modified. The United States Attorney would report on what the offenses were. they'd have to consider whether the defendant had maturity, rehabilitation, and fitness to re-enter society, a victim statement that from any victim, or if the victim is deceased, the victim's family, the judge would have to consider any victim statement. Reports their mental or physical health. You'd also have to consider the diminished culpability of juveniles as compared to that of adults. The hallmark features of youth, including immaturity, impetuosity, and failure to appreciate risks and consequences if the defendant was a juvenile at the time of the offense, plus any other information that the court would determine relevant. This would also create a rebuttable presumption in the case of a defendant who is 50 years of age or older on the date on which the defendant files an application. Under subsection A, there shall be a rebuttable presumption that the person can be released. Now, remember, the only reason that you can file these is for more than 10, having served more than 10 years, or as part of a law being changed or repealed. But people over 50 have a very low propensity to reoffend, and so it is established. Justice is not established by keeping them continually incarcerated. But again, this is a rebuttable presumption, so the prosecutor could demonstrate that the person should still be incarcerated. This is the limits on application. So after we said 10 years, then here's 5 years, then 2 more years, and a final application if they're 50 years or older and exhausted the sentencing modification program. Prisoners would have to be notified by the Bureau of Prisons about this in their 10th year of imprisonment. And there's also the opportunity to expand the hearing, to submit additional witnesses and evidence relating to the motion. And the court shall, upon request of the defendant or the government, conduct a hearing on the motion, ensure that the defendant and counsel have the opportunity to be heard, present evidence. The defendant has to be present, and any defendant who is unable to afford counsel shall have counsel appointed. Again, establishing justice requires that both parties are able to equally represent themselves, and so it's essential that the defendants have counsel. And however they, whatever the finding is, has to be in court, stated orally in court and in writing. And both sides can file an appeal based on existing rules for appeals. And remember, we talked about how victim statements would have to be considered. The attorney, this would create a positive duty for the United States attorney to provide, to notify crime victims. There's a whole section of law of things that they're supposed to be notified to, and this would trigger that. And then there's an annual report. Just, the Blueprint for a Better America is pretty scrupulously avoids identity politics, and so this is one of the few places where we get into demographics, and there's actually a reference to to age, race, and gender of the people who are impacted by this program. People who are denied, who are granted denied such sentence reductions. So the numbers, their demographics, and the location of where these things take place, as well as the average sentence reduction granted under this section. And then there's one technical amendment to add a reference to this in the United States Code. Sorry, two technical amendments. and these would apply on passage October 30th, 2022. So we have a mass incarceration problem in America, and these are steps that we can take to address it. The ones we talked about tonight. We're repealing mandatory minimums and creating the opportunity for people who've been incarcerated 10 years or more to have their sentence reviewed. This is how we can best establish justice. And so with that, we can go ahead and wrap up tonight's session. And as always, if you have any questions, you can leave them in the chat, or you can email me at brian@anamericanunion.com. You can learn more on our website, anamericanunion.com. And in 15 days, join the general strike against Congress, the general strike against the duopoly, the general strike against politics as usual. We, the people, can crowdsource functional government. We, the people, can force Congress to address these problems, these interconnected issues that Martin Luther King identified more than 50 years ago as the triple evils of poverty, racism, and militarism. So, all right, with that, I think that's it for this evening, and we'll see everyone tomorrow.